Hello everyone, good morning. Today I will be discussing Republic Act 8293, which is better known as the Intellectual Property Code of the Philippines, enacted last January 1, 1998. This act prescribed the Intellectual Property Code and established the Intellectual Property Office. But before we go into the details of this act, however, let me define first what the term intellectual property is.
When you say intellectual properties, this refers to any creation or product of the human mind or intellect. It can be an invention, an original design, a practical application of a good idea, a mark of ownership such as a trademark, literary works, or artistic works, among other things.
There are three types of intellectual property rights. These are trademark, copyright, and patent. A trademark is a distinctive design, graphic, logo, symbol, word, or any combination thereof which would identify a company and/or its products or services. This would serve as a guarantee for a product or service's authenticity. It would also give the owner of that trademark the legal rights to prevent its trademark's unauthorized use. However, for it to be valid, a trademark must be distinctive instead of descriptive. This means that if you are selling coffee, for example, you could name it Jack's Black Coffee, but you could not register it under the name Black Coffee. That would be descriptive of the product only and not distinctive at all. After all, you won't be the only one selling black coffee in the market. Well, of course, a trademark should also be affixed to the items sold. I mean, where else would you place them? And most importantly, your trademark should be registered with the appropriate authority to obtain legal ownership and protection rights. If you don't register it with the appropriate authority, then you can't file an infringement case against anyone, even though you really own that intellectual property. Now let's move on to copyright. A copyright is defined as the exclusive legal right to reproduce, publish, sell, or distribute the matter and form of something such as a literary, musical, or artistic work. A patent, on the other hand, refers to the right granted for exclusive ownership for any device, substance, method, or process that is new, inventive, and useful. This would give the patent holder the exclusive right to commercially exploit the invention for the whole period that he or she would be granted the patent. So there you have it, the three types of intellectual property rights. Make sure you don't get them mixed up. Now, there will always be those individuals who would want to imitate your work, and when that happens, you can sue them for intellectual property infringement. Just make sure that you legally own that intellectual property though before you file a case against them. There are different types of intellectual property infringement. We have the copyright infringement, patent infringement, and trademark infringement. Basically, they only refer to cases wherein other individuals infringe or violate the legal owner's exclusive rights to a certain product or service by imitating the original designs or intellectual works, reproducing it, and then distributing it or displaying it to the public without permission from the intellectual property right holder. This infringement is done mainly to confuse or deceive the buyers into thinking that the product is genuine or belongs to the original maker, even when it does not. Of course, if this case happens to you, you wouldn't be happy that somebody else is making unfair advantage over something you have come up with in the first place, would you? So, to protect you from those kinds of situations, our country has established the Intellectual Property Office. This office coordinates with other government agencies and private sectors to ensure that the policies and plans under this Republic Act are being implemented and the use of patent information promoted as a tool for technology development. This office also decides whether or not to reject or legalize a certain application for patent on inventions and other matters relating to intellectual property. It also settles cases involving intellectual property rights. What would happen now to those individuals who are found guilty of the crime of intellectual property infringement? For the first offense, it would only mean imprisonment of 1 year to 3 years and a fine ranging from 50,000 to 150,000 pesos. For the second offense, it would be 3 years and 1 day to 6 years, plus a fine ranging from 150,000 to 500,000 pesos. Now, if that person still didn't learn his or her lesson not to infringe on other people's intellectual property rights, then he or she will be imprisoned for 6 years and 1 day to 9 years, plus a fine ranging from 500,000 to 1.5 million pesos. Now, supposing that individual doesn't have the money to pay for the fine that the court has imposed, then he or she would have to pay it off by staying in prison until his or her prison time becomes equivalent to his or her monetary debt. This is what we call the subsidiary imprisonment.
In the Philippines, the office or the lead agency in charge of the control for intellectual property is the Intellectual Property Office of the Philippines, or IPOPHL. It has been created by law, specifically Republic Act 8293, which took effect on January 1 of 1998 under the presidency of Fidel V. Ramos.
So if I were you, be original. Don't even think of committing any intellectual copyright infringement. It's really expensive. After all, I'm pretty sure you wouldn't want to spend your years languishing in a prison cell either. Now, enough with all the details. I'm sure you already understood the basics. Let's move on to some cases which will explain the concepts further. For that, I have prepared a documentary for you. Watch this.